Hey, it is 7 o'clock. Good evening, everybody, and welcome to this evening's Licensing and Public Protection Committee, being held today, Tuesday, the 17th of January, 2023. Can I remind everybody that this meeting is being broadcast live on YouTube and recorded for publication at a later date? Can I ask that if members wish to speak on any of the items of business this evening, could they raise their hand so that I can identify them accordingly? May I also ask members that in the unlikely event that we need a vote on any of the items this evening, that they make me aware at the appropriate time. Thank you. We'll move on to this evening's business then, and item 1 on the agenda is apologies. I have received apologies from Councillor Simon White, and Councillor Wendy Brocky has put in apologies on behalf of Councillor Ruth Wright. Councillor Brocky will also be substituting for Councillor Wright this evening. I take it there is no more apologies since every other member is here and present. So we'll move to item 2, which is declarations of interest in relation to licensing matters. Do any members have any declarations of interest on licensing matters? No, take that as gone then. So item 3 is minutes of the previous meeting. The minutes of the previous meeting can be found on pages 5 to 8 of your agenda pack. Are members content that these can be taken as read? Yes, we're all in agreement with that. Item 4 is relaxation of licensing hours for His Majesty the King's coronation, Licensing Act 2003 consultation. This report can be found on pages 9 to 26 of your agenda. I will now hand over to Matt, who would like to present this report to you all.
Thank you, Chair. Good evening. So the first of the reports is about a relaxation of licensing hours or a consultation as to whether or not there should be one nationally. The Home Office have started a consultation. It's not closed yet, which would allow certain licensed premises to be open later than normal over the weekend, the bank holiday weekend for His Majesty the King's coronation. Just a bit of background, there's a provision in the Licensing Act that allows the Secretary of State to make these sorts of orders in occasions that are exceptional, international, or have national or local significance. They've used them before for the Queen's Platinum Jubilee, royal weddings, 90th birthday celebration for the Queen, and some of the large sporting events as well. As you'll probably be aware, there was the bank holiday weekend or the extra bank holiday weekend in May this year, with Monday the 8th being designated, with the coronation taking place on Saturday the 6th. So what the consultation is whether or not there should be a licensing hours order authorised by the Secretary of State to allow certain types of premises that are already open to sell or supply alcohol for consumption on the premises, and then for them to have regulated entertainment from 11 p.m. until 1 a.m. So it's only relevant for those premises that already have a license up until 11 p.m. Anyone that closes before that wouldn't benefit in this way. And the same if it's someone who opens until 12 or 1 o'clock, they don't get a 2-hour extension. It's merely for those people who cease at 11 or around 11 to allow them to open a bit later. So it wouldn't apply to some other types of premises. So it wouldn't apply to premises that have consumption for off the premises, so off licenses, supermarkets, those types of places. It wouldn't benefit late night refreshments premises because they would have a late night refreshment license from 11 p.m. anyway. And it obviously doesn't relate to any sort of unlicensed premises either. The consultation document, the full consultation document is Appendix A to the report. It opened on the 19th of December and it closes on the 23rd of January. So what we're seeking to do is put our thoughts to the committee and hopefully have you agree with what we say. 2.4 in the report and also in the consultation itself, it asks a number of questions. Firstly, do you support the proposal for extending the hours for the coronation celebrations? Do you think it should only apply for the sale of alcohol for consumption on the premises? Should it be for England and Wales? and then should it be for Friday into the Saturday, Saturday into the Sunday, and Sunday into the Monday. And then if you do disagree, then to give reasons. Our view is that, yes, it meets the sort of threshold of type of events that would be suitable for this type of order, but it should apply for all 3 days. And we think it's right, it's first the premises that have the sale of alcohol for consumption on the premises rather than takeaways and off licenses. So our recommendation is that members sort of note there's a consultation there and agree with officers responding yes to the questions 1 to 6. And then we don't need to respond to number 7 because we're not disagreeing with anything. There isn't any more than that. Happy to take any questions. Thank you.
Okay, thank you, Matt. Do any members wish to ask any questions or make any comments? They have silence says it all. Councillor Sweeney.
No, I think it seems extremely common sense. I'm happy to move the recommendation. Thank you.
I take all members in agreement with that, that you're happy to note and support the proposed consultation. Yes, carried. Then we can move on to item 5, which is the updating of section 182 guidance to make reference to spiking, Licensing Act 2003 consultation. This report can be found on pages 27 to 50 of your agenda. I again hand back to Matt, who will present this report to you.
Thank you, Chair. Yes, second consultation. Sometimes you get none, sometimes you get several all at the same time. This one relates to the section 182 guidance, which relates to the Licensing Act. It's statutory guidance that we have to have regard to. It does occasionally get updated by the Home Office. Sometimes they consult upon matters that they're planning on putting in, sometimes they don't. This happens to be one of the matters where they've decided that it should be consulted on. One thing to note in this is that the consultation was short and the period actually closed on the 13th of January. As such, we have submitted a response already in consultation with chair and portfolio holder. So I'll go through what the proposal is and what we've said. Just to offer a bit of background before I do, you'll probably all be aware, it's been mentioned at committee previously, in relation to a Home Office investigation inquiry about spiking or alleged spiking as a sort of phenomenon around the country in the nighttime economy. That happened in 2021. They had quite a lot of responses to that, both from victims and from witnesses. And then a Home Affairs Select Committee published quite a lengthy report. It's available. It's linked to the report if you do want to have a look. And within it, there was 22 conclusions and recommendations for government to work upon or act upon. There were 2 that were specific to local authorities and the Licensing Act, and they're at 1.3 of your report. The first one is primarily around having training or compulsory training for members of staff who work at music festivals. So whether that's bar staff, vendors, door staff. So they're proposing that is something that is rolled out as a mandatory requirement for those types of premises and those types of events. And the second recommendation was around what the government is or is not doing currently in relation to monitoring these types of events and the powers available to local authorities when it comes to these types of premises. So I won't read through the entire recommendation, but part of it is to review the guidance, which has led to this consultation, with a view to requiring licensing authorities to consider the prevalence, the prevention and reporting of sexual harassment and misconduct and gender-based violence in the statements of local licensing policy. So part of it is looking at this particular guidance, and part of it is looking in our policy, which will be due for renewal in a couple of years, to add some specific information around what we expect around these types of matters for reporting and prevention. So within the consultation document, which is appended to your report, the government offered a response to all of the recommendations within there. The government agreed that the committee had safeguarding training for staff for those types of events for festival, and it also, in relation to the one around the guidance and our policy when it comes to be renewed, was that there's already a lot going on in terms of the local areas, a lot of money being spent on late night economy, the Safer Streets Fund, the Safety of Women at Night Fund, and there's quite a lot of projects throughout the country looking to sort of tackle that. They also mentioned the guidance again in terms of what could be done to strengthen council's powers if required, and whether or not there should be reference in the guidance to what should be included to specify what councils and local authorities should be doing when they hear of a premises which has those sorts of incidents taking place or allegedly having those taking place. Excuse me. So the conclusion really was that the government were going to look at the guidance, and that's as I say, the purpose of the consultation as to what needs amending or what could be amended. So in terms of the consultation itself, it's at 2.4 again. There's 4 questions. We have, as I say, responded already, and our responses are included at 2.4 as well. But the questions asked are: do you support the Section 182 guidance being updated to make a reference to spiking? And the council view is that yes, it makes sense. There's quite a large prevalence, increased prevalence over the last 18 months. So it makes a lot of sense for that to be included. In our view, spiking of all its various natures falls within the public safety and the prevention of crime and disorder objectives. So we think that's a highly sensible recommendation, and we've said yes, that we think that's correct, the correct thing to do. The second question was: do we agree with updating the guidance to encourage the local authorities to place additional conditions on licenses to safeguard their patrons? Again, we thought that's entirely reasonable and sensible. We do already have powers to do that. I'm happy to say we haven't had anyone come to committee for alleged spiking so far. But if we do, there are powers for us to take against the license and add conditions if we thought they were sort of appropriate to help mitigate those. So again, we've answered yes to that. Question 3, do we support the guidance being updated in relation to the sexual harassment, misconduct, gender-based violence, and including elements of that within our local policy? Again, entirely sensible. We already include other areas or matters within there. So we said, yes, we agree with that. And the 4th one was: do we support the collection of data from local licensing authorities on the use of powers to impose conditions or revoke premises license in relation to these types of matters? We've already asked every other year for quite a lot of data from the Home Office in relation to licensed premises. So I can't see any problems, or we can't see any problems at all with having this as additional questions or piece of information that they want to sort of study. So again, we said yes, seems entirely reasonable. There is the copy of the response that we've sent. The full response is attached to Appendix B of your report. Again, I've got no further questions, just the recommendations. Members note what we've said and agree, hopefully, with what we've proposed. Thank you.
Hey, thank you, Matt. Do any members wish to raise any questions? Councillor Brown.
This seems a very sensible move, and I agree with your responses. But I'd just like to ask, who would provide the safeguarding training? Because it's quite specific, isn't it? And needs quite an up-to-date approach. So I'm wondering who would provide that and who would sort of certify it.
They haven't said anything yet. I would hope there would be a national sort of curriculum, if you like, or a national course with approved providers. I can't say that's definitely what would happen, but that would seem the most sensible thing if it was going to be mandated as part of a statutory provisions that that's the case. There are certain initiatives out there that offer this type of training. So Ask Angela and a few other sort of late nighttime economy forums and organisations. So the honest answer is I don't know. That's the way I'd like to see it go if it does become something that needs to that does get implemented into the Act.
Thank you, Matt.
Councillor John Williams.
Thank you, Mr. Chairman. Firstly, is there any money that follows this for the Borough Council? What do you expect to receive? The help of policing. I agree with the report and the consultation has been very good. Something needs to be done. So first, really, is any funds that the Borough Council are you expecting to have? And the other point, it's just a minor one. If you get a premises that had more problems with spiking than any others, what would the response be to that particular premises? Would you actually go in and police that? Thank you.
In terms of funding for this particular point, I couldn't say because it's just a proposal at the moment that's being consulted upon. It would depend very much on what the government were mandating us to do. Regularly, if the government mandate that the local authority has to do something rather than it being sort of voluntary to do, then we get something called a new burdens payment. And that'll depend on the amount of work and the type of work that needs to be undertaken. So for an example, when they introduced the pavement licensing scheme over COVID, we received some payment from the government to instigate a new scheme. And that went towards what we did for pavement licenses. And it's similar across the authority for other new areas that are brought in. So that's potentially one way. If you're talking about funding for sort of safer women at night campaigns, there has been some money that's come in through funding, which Michelle and Jason would probably actually be better placed to speak about. But there is some money there, and there's a programme that's being run it's on Friday nights in the town centre to assist. In relation to your second point as to what we do, obviously it'd be very case by case specific. There's lots of different matters or ways of dealing with it. If it was an allegation, then it would be officers visiting, speaking to them, seeing what measures are in place. If it's a type of premises that or activity that might have to undertake this training, then we'd have to see whether or not they had done it. If it wasn't one that had to do the training, we would probably suggest that they went out and got some from an approved provider. If it was more serious, then the police would probably be leading on it, if I'm honest. They'd be investigating any allegations, any confirmed cases. They would then have a multi-armed approach. So they'd be able to call for a review of the premises license, which is when it would come before yourselves with all the evidence in relation to it and what action could be taken, which could be anything from the addition of conditions, which is partly what this consultation is talking about, all the way up to suspending and revoking a license if there's serious enough and the matters aren't being taken seriously enough by the premises and sort of the people who work there. The other arm obviously is there are various offences, although not one specifically for spiking, and government has said that they're not going to introduce a new one specifically for it. They could prosecute members of staff for sort of allowing it, facilitating it, but more likely the perpetrators, if they're able to catch them, for one of several offences that exist out there already, which if they were then a licence holder, a premises licence holder or a personal alcohol licence holder, which then would bring about the remit as to we would then be able to look at their licence as to whether or not they keep it.
I think it's a great idea. Anybody who's got a daughter or a young thing who's going off to festivals and so on. But at the moment, there seems to be a lot of grey areas that need to be filled in. How do you demonstrate evidence of compliance, which would have to be done beforehand? The police that you mentioned, I think, because of their training skills that they have, might be the best people to discuss training with, because they have a lot of interpersonal skills with the public. But it's the evidence of compliance and how long that has to be done before the license is granted. A lot of the data seems to be after the event, which shows there's a need. But you also need to make sure how much detail is given to people beforehand so that they know what they're committing themselves to. You've got all sorts of different scenarios. You've got the sort of wedding scenario, you've got the festival scenario. So you've got the people who run it, the visitors, the vendors who just come and sell the wares and so on. It's a multi-purpose thing that has to be tailored. That's the only comment I would make.
So specifically in relation to events, it isn't set on size, scale, nature, but if it is a larger event, then typically we'll have something called a safety advisory group, which is chaired by a member of the environmental health team, but it incorporates police, trading standards, the various elements of environmental health, and ambulance, fire service, people like that. And what we would expect from a person well in advance of a license application is an event management plan, a noise management plan, and various other sort of safety considerations, risk assessments to be put in place. And we would want to see, in relation to whatever it is, that they've thought about it, they've mitigated as much as they can, what they're putting in place to help or prevent certain issues from arising. As this is only consultation at the moment, the proof will be in the pudding as to what actually gets mandated. I would suspect there would be some criteria as to what premises, what type of events would be caught by this. So just saying festivals is too vague. You'd need to know size, you'd need to know nature, you'd need to know whether there are any exemptions or anything else. But once it's mandated as part of the risk assessments and safety advisory groups and the other measures that we sort of have in place, we'd be able to see we'd be able to make sure that what is law was being complied with prior to, hopefully prior to making a license application. But we would also then expect in a license application them to include conditions as part of their operating schedule that says, we will do this, we must do this, we can't go ahead unless all our staff, people present, have undergone this training, that sort of thing.
At the moment, it seems to be from the paper that the umbrella provision legally is non-mandatory. It did say non-mandatory. I don't think I've misread it. So it means that you're probably going to get different strengths of this being implemented across the country, depending on which local authority it is. Is that right?
Currently, it's every licensing authority for themselves, as it is with many sort of licensing and regulatory matters. Taxis, yes, let's not. Not today anyway. Everyone looks at it differently. There will be guidance, there is guidance out there as to how people should look at it and react to it and what we should think about, but it's always up for discussion, and people have their own views as to what's relevant and what's not. And if you gave the same license application or same idea to two different licensing authorities, you'd probably get two slightly different answers. If you gave it to the 300 odd of us, you'd probably get 300 different answers. But you'd hope we'd all be going in the right direction in terms of the public safety aspect, which is what we're all tasked with doing. And it would be a similar recourse if we knew there was an event happening that was X many hundred or thousand of people in the borough or the district. They'd tell us, we'd get them in the room, we'd say we want to see X, Y, Z, hopefully before they come and see us, but if not, please provide these to us by this time, and we'd go down that route. But yeah, you're right. people see things in different ways, and some events would be more suitable to this type of provision. Some of them probably not so suitable. But I think we'll have to see what comes out of it.
Thanks, Matt.
Barker.
Mine isn't about pubs, dance halls and that. I'm very interested. The Borough Council own a lot of community centres and a lot of them are licensed. Now, I've recently gone on a committee and they keep on about we need a licence. How are those centres going to be monitored? Just in, say, you wanted the centre for a full day for a party with alcohol served. Who monitors that? Is that the committee or?
So every premises license will have conditions attached to them, and they're always case by case specific to that type of premises and the type of activities they undertake. Community centres tend to be a little lower risk than some other types of premises, but what we expect, but what is expected in the law is that as part of an application, the people who are submitting the application put forward measures, conditions, it's called the operating schedule, as to how they're going to meet the licensing objectives. The monitoring of that it's an ongoing thing. If we're aware that there's a problem and so a condition isn't being met, then we can speak to them, the police can speak to them, as can any of the other responsible authorities. If it's an after the fact, a complaint that something's happened, then there's potential for investigations again as visits and sort of stronger action as well. But it's always very case specific, premises specific, event specific almost. And a community hall can cover quite a vast different amount of events or types of events different to what a pub might be. So a pub may be very generic in terms of what they do, whereas a community centre can be used for multiple types of activities, but then we would expect an operating schedule to cover all those different types of activities and the risks that they bring.
Any other members wish to speak? Michelle, Jason, Steve, do you would like to elaborate any information to help our members?
Yes, thank you, Chair. So we're moving on to the next agenda item.
You know, then. So are members happy to note the content and the consultation responses that's been submitted? Okay, that's carried. Six is the minutes of the licensing subcommittee meetings. These minutes can be found on pages 51 to 54 of your agenda pack. Members take these as being read. Noted. Okay. That concludes the licensing business this evening. We'll now move on to Public Protection Committee. So item 7 is declarations of interest in relation to public protection matters. Do any members have any declarations of interest? Councillor Heatham.
I don't know if this is a declaration of interest. It's just to mention really that the next 2 items come under my cabinet portfolio.
Okay, that's noted. Yeah, fine. Yeah, that's fine. Item 8 is the first of the Public Space Protection Order public consultation update. This first report can be found on pages 55 to 72 of your pack. I'll now pass over to Michelle, who will present this report to you.
Yes, thank you, Chair. So the first report we're going to look at is in regards to the public space protection order for the Newcastle Town Centre and Queen Elizabeth Park. So members will be aware that this report has been before you previously in order for us to undertake formal consultation around what that order looks like, what the conditions are, what behaviours are that we need to challenge and what we need to address, and also obviously the area that that order needs to cover specifically.
So from the last meeting we had, which was back in October, we've conducted a further 6-week consultation. This was undertaken from the 18th of November to the 26th of December. And a total of 33 online responses were submitted for that. Overall, there was a 91% agreement with the conditions that we are looking at and the actual mapping area that we're looking at as well. A full copy of the report in regards to the consultation results, it can be found on Appendix 3. Appendix 1 shows the final drafted order for Newcastle Town Centre and the final conditions that we're looking at introducing. And Appendix 2 to that is for the same thing, but for Queen Elizabeth Park. So we are now in a situation where we've completed our formal consultation with members of the public, and we are now looking for members to confirm and approve for that order to be implemented in Newcastle Town Centre and Queen Elizabeth Park. Happy to take any questions.
Any members wish to raise any points, questions, comments? Councillor Mrs. Jill Williams. Councillor Williams, can you use your microphone, please?
Can we now look forward to rolling out a programme to look at other areas? Now we're looking at these 2 areas. I mean, a lot of these people who will be moving out of the town, I've said it before, go into Crossy. We've got a mineral line there. We know are drug takers, antisocial behaviour. And then we know they're selling drugs to the students who walk along that lane. And yet nothing's done whatsoever. So is that something we can start looking at now?
Yeah, so obviously to answer that, the public space protection orders are one element of the legislation that we can use in regards to addressing matters of antisocial behaviour. We're using it in the town centre in Queen Elizabeth Park because at the moment we're able to demonstrate the behaviours that are specifically causing an issue in those areas. Now, when we look at displacement problems, that's another kettle of fish we really need to look at. And obviously we can look at public space protection orders, but obviously as in addition to that, there's a whole array of enforcement powers that the local authority and the police have in regards to addressing those issues. Some of them antisocial behaviour, some of them criminal that you've mentioned. So I think it might be for an open discussion outside of this meeting so we can look at some of those issues that you're having, whether we sit down with the local policing team as well to start looking at how we can address them. And just so you're fully aware of any other operations that are ongoing in those areas as well.
Councillor Sweeney.
Thank you, Chairman. I might be confused myself here because my computer went off halfway through, but have we not missed a section on this? We've jumped to number 9. We haven't done number 8 yet, have we?
Apologies. That's
right.
because, sorry, in regards to the title on the agenda, we were not sure which way round it was in terms of that. So yes, okay. So we've gone to item 9. We'll refer back to item 8 after.
I do apologise. I did ask Michelle before the meeting started and I should have made members aware of that. So apologies for that. You wish to speak?
It's a comment more than a question. The lady said that, you know, there needs to be many more of these orders. If you do a blanket order like that over every space that younger people can use, it tends to be less effective and seems far too draconian. If you pick the worst ones and the word gets around, sometimes by making an example, that is good enough.
Yeah, and I agree. And obviously we have to, we work with other neighbouring authorities all the time in regards to best practice, what best practice looks like in regards to how we as a local authority can use the legislation that's available to us to address that and have the most effect. And obviously the PSPOs in this situation are specific to those issues that we can address in the town centre. We also do have PSPOs across the borough, but they're in relation to dog control orders. So we can utilise the legislation as we need to and as we can demonstrate that there's a need to.
My only other comment is excellent report. Thank you.
Thank you.
Councillor John Williams.
Thank you, Mr. Chairman. I mean, maybe the point is we haven't got enough police and PCOs actually to do the work that's needed. That's a starting point. Whereas, yes, I agree with the report. We need to solve some of the problems in the town centre and Elizabeth Park, which I know very, very well. And it's sad that that park now has been reduced. If anybody wants to visit that, it used to be a really well kept park. And it's been reduced to a rather rougher than it was. That's all I'll say. But really, you know, we need more people to actually go out enforcement, to go out and police the areas other than in the town centre. I know you can report and police will look at different areas, but there still is not enough people to actually look at the problems we have got in the estates. Thank you.
Yes, so just to answer that, in regards to the policing of this order and the enforcement of this particular order, it's obviously going to be a partnership approach in regards to that. There's going to be an element of the police doing their part in terms of issuing fixed penalty notices for non-compliance to this order. But as well as that, members will be aware that there is a new mobile multifunctional team that's in development at the moment, and there is scope and perhaps development within that team to look at doing the enforcement for these orders as well, similarly as they do already for the PSPOs for dog control orders.
To do a fantastic job, but I'm just saying there isn't enough police to actually do the work that needed to be done. Thank you.
Any other members wish to speak? Councillor Sweeney.
No, I think when you read 2.1 on this, and that as you were, it's not 2.1. Yes, it is 2.1. The lowest support, the restrictions related to vandalism, 88% is the lowest, up to 96%. So I really think it's a easy decision to make, isn't it, on this? Thank you.
Take it nobody else wishes to speak. So are the committee happy to consider the contents of this report, and are the committee happy to give approval for these orders to be adopted in line with the constitutional requirements? Okay, that's carried. Hey, that was item 9. We will go now to item 8, which is the Public Space Protection Order Public Consultation Update. This report can be found on pages 55 to 72 of your agenda. I'll hand back to Michelle, who will present her report to you.
Thank you, Chair. So this is a new report in regards to a new proposed PO that we're looking at, and this is specifically in regards to gated public rights of way. So just to provide a bit of historical context around this, previously as part of the legislation, the local authority was required to apply for gating orders where we were proposing to restrict access of public rights of way. And basically what as legislation has changed, that new legislation is the PSPO. So we are now looking at implementing a public space protection order that will cover some of the public rights of way that are currently restricted, partially restricted, and that is where they are opened by residents morning and night, and a future looking forward proposed gated public rights of way that we're currently looking at moving forward. So let me just take you through the report. This report's come around due to ongoing reports of antisocial behaviour in specific locations. So the Borough Council is obviously looking to utilise its powers to impose specific restrictions and prohibitions that will restrict antisocial behaviour, and in some cases restrict arson in the locality, and that will be done via restricted or partially restricted public rights of way. So this is the first order in regards to public rights of way that we've been looking at. But again, the proposal and the process of formalising this order is the same as we've previously discussed with the town centre PSPO. We'll go through the areas one at a time, and then obviously if you have any questions, we'll take questions at the end. So the first one is in regards to Newcastle 132, which is BT Avenue. So members may be aware that we've had historical issues in this particular location, specifically around antisocial behaviour and arson, some quite considerable arson attacks in this particular location, where a number of properties have had sheds, all the fencing, hedges be targeted. Now, despite attempts in terms of criminal investigations into that, we still find ourselves in a situation where we haven't identified the person that's responsible for doing that. It does seem to be a seasonal issue, mainly from March through to June, where these properties are targeted. We are obviously unsure what those reasons are, but we need to provide a bit of reassurance to those properties in that location in regards to what we as a local authority are able to do to protect them and to provide them some more safety. There's been a lot of work that's been ongoing in this particular location with Aspire, who own a lot of the properties in this area, where we've ripped out hedges, obviously, that are quite an easy target in terms of arson attacks, and they've been fully replaced with either concrete fencing or alternative fencing. We find ourselves in a situation in this location where residents have found it upon themselves to actually install their own CCT for the purposes of protecting their rear gardens. We've had issues of people popping over the fence and targeting all sorts of property in that garden in terms of arson attacks. So it's quite a serious issue that we have in this particular location. The next one is in regards to Kids Grove 19. So this is located on the High Street in Newchapel. Now, this is a historical gating location. It's been gated for quite some time. It's partially gated in regards to it's opened by the residents of the neighbouring properties. They are the key holders for that particular location and have been for quite a considerable amount of time. They open that location in the morning and they lock it back up at night. Again, historically, this location has suffered with antisocial behaviour due to the context of this public right of way. So it's between two terrace properties where the property overhangs the actual public right of way. So it goes, any noise or any issues are obviously felt quite considerably by the neighbouring properties there. The gating that's been in that location for that time seems to have resolved that issue. So obviously the proposal is for that to continue as it is at the moment. The next public right of way we're looking at is in regards to Newcastle 143. So this is a gated alleyway off Church Lane in Woolstanton. It can be accessed via Woolstanton Marsh. And historically, we've had issues at this location. I'm sure a lot of members will be aware of issues around antisocial behaviour we have on the marsh itself. And concerns raised by residents in that location of the alleyway being used for antisocial behaviour, drug taking, escaping criminal offences from an easy access way from the marsh. Now, again, this location has been gated for quite some time. So we find ourselves obviously backtracking and making sure we've got the right legislative orders in place to ensure that we're complying with the gated public rights of way we want in the borough. So what we're looking for from members is to start a consultation. As per the previous PSPO we've discussed, we need to obviously do a consultation in regards to these public rights of way. Are members of the public happy for these public rights of way to be restricted, partially restricted, and to really ascertain what appetite there is for that. And not only that, it will also allow members of the public to make suggestions in regards to other public rights of way that perhaps they would like gated and things like that. And it's things that we can then progress moving forward. So the proposed order, it would be in regards to those locations. Each one is obviously specific. So in regards to Appendix 1, we're looking at Newcastle-under-Lyme. There is an alternative route there for pedestrians via an alternative avenue. So I don't ascertain any particular issues in regards to the consultation there, but it is a very busy public right of way. In regards to Newcastle-under-Lyme, that's found on Appendix 2. We were looking at the gating to be in place with immediate effect as it already is, and to continue moving forward. And in regards to Kidsgrove 19, which is on Appendix 3, we're looking at the restriction of that public rights of way through particular hours, so from 6 o'clock in the evening through to 8 o'clock in the morning. So what we're asking members for today is for us to move forward and initiate a initial 6-week consultation. A report will then be fed back to this committee in regards to the findings of that consultation. Thank you.
Thank you, Michelle. Do any members wish to speak other than the two? Councillor Williams. Councillor Jill Williams, the floor is yours.
I fully agree with the BT Avenue, what you're planning to do. When you say you don't think that we have a problem with some of the residents, I think we will on Hollywood, where all that extra traffic will come through, because there's an awful lot of people. It is a cycle path, and there's an awful lot of people on cycles who come that way, and dog walkers, believe it or not, because they don't have to go through the estate with the dogs, and they just go straight through to the path. So I do think we'll have a few. I do think we need a good consultation on Honeywood, because we will see just a few problems.
I think the whole purpose of the consultation is to get a feel for the support in regards to these locations. It may be that as a result of the consultation, we look at only restricting that access through the hours of darkness, again, like we've done in the Kidsgrove area from 6 till 8 in the morning. We can probably demonstrate through evidence that that's the key times that we're having these issues. So obviously it depends on the feedback that we get as part of the consultation.
That's very noble of you, Councillor Williams. Councillor Wheeldon, would you like to come in and ask your question before I hand over to Councillor Williams?
Once these areas have been audited and the report produced, is there a proposal to look at other areas? I'm thinking of a particular area within my ward where I've had a number of complaints from householders. And it tends to seem to be where, like you say, where there are open spaces that have been sort of left open by people like Aspire or other developers who haven't quite finished off and just left it as an open space. I've had complaints of drug exchange, fly tipping and that sort of thing, which have been dealt with, and they're a lot better now, but they are open areas. It's the back of Orme Road and Snowgoose Way. It's sort of, there's a big open area sandwiched there. And it's sort of quiet and out of the way, and all sorts of nefarious activities have a sort of preponderance to actually go on there. I was just wondering if those sorts of areas were going to be looked at once this is tidied up and dealt with. Is it going to be expanded?
So the order is specifically looking at public rights of way as defined by Staffordshire County Council. Is that right? So yes, in that case, obviously, if there is scope, we would have to look at obviously the evidence in regards to what was going on there in terms of trying to include that, and also look at the cost implications in regards to what it would take to restrict the access at that particular location as well. So for example, for the Newcastle-under-Lyme, we've managed to secure some funding from the PFCC's office in regards to the issues there, purely on the basis of the high volume of ASB and arson attacks in that particular location. But needless to say, yes, we could potentially look at that.
Thank you. The only reason I raise it is, apart from all those things that you've said go on in these spaces, There's a community centre there that with loads of graffiti, parts of the roof have been ripped off, the guttering's been sort of ripped off and so on. So it's starting to escalate there, and it's probably one of the areas that needs nipping in the bud once you've dealt with this package.
Yes, absolutely. And obviously any issues in regards to anti-ship behaviour in your area, if you want to discuss them with me, then I'm happy to look into them.
Councillor John Williams,
Thank you.
please.
I admire the officer to actually take this on, because in a few years ago we managed to close public right of way in Cross Heath. So I admire because there's a lot of work going to go in this, because the responsibility for footpaths on the definitive map is the county council. So you've got to go through them and all the rest of it. So yes, I agree that the one at BT Avenue I'm talking about, the 132, the problems we have there, and you just mentioned you shut it in the daytime. Who will that be responsible for that? But that's for the future. So the consultation really, firstly, what kind of consultation? Because it's been, as Councillor Jill Williams has said, people in Honeywood, a lot more traffic would go because it is on a cycle route from Maybank and Woolstanton down across by St. Martin's, Emsall School, across there, working your way to the town centre. It was designated as a cycle path, get people to use it and walking and dog walking, get people more exercise. So the 132, if you look at the map at the top right left-hand corner, really that pathway is not hardly used. I should probably declare interest because our garden backs onto it. That's farther up, but I won't go into that one anyway. But so a majority of the traffic here will go through, will come down from Woolstanton and Maybank, round the corner by the pumping station, if you left-hand turn and right then into Honeywood. So really the consultation, what kind of consultation, and can the local councils themselves help in that consultation? But again, best of luck with trying to get this public right of way moved to the. I could go on forever about it because they're involved with the development and all the rest of it, but I won't. But anyway, best of luck. So it works out. Thank you.
Thank you. So the consultation will predominantly be an online consultation, but in addition to that, what we will be doing is sending out letters. So we previously had a community meeting with the residents of Honeywood and BT Avenue. They were invited along regarding in the initial stages when we were looking at what we could do to address the issues in this location. And at that point, it was suggested that there was quite a considerable amount of support in regards to the gating in this location. Needless to say, at that point, obviously, we did have a few residents on Honeywood who were concerned in regards to, altering the traffic flow down through that location. But like I say, we'll send out letters to all of the residents. They are expecting it because they knew this was coming anyway. So they'll have an ample opportunity to, put their views forward.
Yeah. Sorry to check. Look about the houses on the right hand side. If you're walking from Blackenberry, Honeywood, the ones on the right hand side, the left hand side back onto this alleyway, and of course the ones in BT Avenue. But will all the residents in Honeywood be asked? And we weren't invited to that meeting that you had with the residents. I did make a representation, but we weren't invited. This is on the boundary of Cross Heath and Maybank, but we represent the people in Honeywood, and we weren't asked to go to the meeting. But there we are; it's all gone now. But those people need to be involved with the consultation. Thank you. Thanks, Chair. Thanks for letting me go on. Thank you.
Yep, and apologies for that. I think it was a very quick meeting that we needed to pull together, and that's a mistake on my part, so I do apologize for that. But yes, going back to your original point, all members of the community in that location will be consulted, as this will impact them all, irrespective of which side of Honeywood they live.
Michelle, may I just add, going further for future projects and what, could the ward councillors be invited, whether they are residents or not, please, if that's okay?
Yes, noted.
Do any other members wish to speak? Councillor Brown.
Just quickly, both Councillor Adcock and myself have a lot of reports of antisocial behaviour in the summer months of vehicles using rights of way, like the Haying Wood area. After discussing it with the PCSOs, etc., they mentioned certain type of gates that could prohibit quad bikes, mopeds, etc., entering areas. Have you got any experience of those particular gates, or could that be part of your plans going forward?
So moving forward, there's been quite a considerable amount of work going on in the background in regards to the Borough Council's compliance with the Equalities Act in around gating of public rights of way, specifically looking at some of our hotspot locations and making sure that we are allowing access to all. So some of those gating suggestions that you are referring to will be compliant of that. But in some regards, there's many different schemes that we can get up and running that will restrict access to vehicles, but will allow access to, legitimate users of these locations. But I'm also conscious at the same time that if you have to allow access if it's a bridleway as well as a public right of way, and you have to allow access for a horse, you're going to allow access also at the same time for a mini motorbike. So we can restrict it to a certain degree, but unless you are completely blocking off that public right of way, I don't think you're ever going to resolve those issues in regards to restricting some of the unauthorized uses of those public rights of way.
I realise it's a balancing act with accessibility. Thank you, Michelle.
Other members wish to speak? Silence says it all. Okay, so can this report be approved as per the recommendations that have been set out before you? Okay, that's carried. Item 10 is an update on results of taxi licensing appeal. This report can be found on pages 97 to 100 of your agenda, and I will pass over to Matt, who will present this report to you.
Yes, thank you, Chair. I'm afraid it's a report of not much has happened. We do try to bring the results of the appeals to members. The last time I brought to report to you was the October meeting. Since the October meeting, we've had 2 magistrate court appeals. The first was from a decision in July 2020 to refuse to renew a taxi driver licence due to quite a long history of matters. It was delayed for quite a long time, firstly because of COVID, because the courts were closed for quite a period of time, as you're aware. It was then listed for some unsuitable dates, and we've actually made it to court twice recently, but whilst we've been there, the court decided there's not enough time to hear it. So it has been relisted again, and we're due to hear that one on the 17th of April. So hopefully we will have that resolved in 3 months' time. The second one in the magistrates related to a subcommittee decision from November 2021 to revoke a taxi driver licence after the individual was implicated or allegedly implicated in a violent assault. There was originally doubt from us that he'd submitted his appeal in time. However, the judge did allow that. So we heard the appeal finally on the 12th of December. The appeal was dismissed. The council was successful and we were awarded our full costs as requested of £2,000. However, that appeal has now been made onwards to the Crown Court. We don't have a date for that yet. So that matter is still ongoing. In relation to the Crown Court, we've had 4 appeals since the last time we've reported to you. The first was adjourned on the day that we were there. We were ready to go, but the applicant and his solicitor weren't aware of the date, so didn't attend. We have a new date for that in May. The second and third relate to the same person, but for 2 separate matters. Again, all parties were present, but it was adjourned on the day due to lack of court time. And the fourth matter was withdrawn less than a week before it was due to go ahead. So the council are considering whether to make an application for costs in relation to that. Actually, I should say, since this was drafted, we have written to them stating that we're going to be doing that, and they have offered to pay some costs. We just now need to determine whether or not we're happy with that, or whether we need to make a formal application to the court in relation to what we would what we wish to recover. So I'm afraid not a lot has happened, but not a lot has happened. At the time the report was written, we have 4 outstanding appeals in the magistrate courts, including the ones we've referred to earlier, 6 in the Crown Court, including the 3 that have been referred to in the paragraph before, and that potential cost application. And as ever, as we have subcommittees or matters that come before us that need dealing with, we I say run the risk, that's not quite the right term. There's always the opportunity for the person to make an appeal to the court, and for these matters to go on and roll on. We certainly weren't helped with courts closing in COVID, but that's all over now. It's just them catching up with other matters that are going on, and a lack of resources, I think we all know. So happy to take any questions. It's just for members to note that what we've been doing since the last time we reported to you. Thank you, Chair.
Thank you, Matt. Any members wish to speak? Councillor Sweeney.
Yeah, thank you, Chairman, and thank you, Matt, for not the most exciting report. But noted that the one we have a result on, we won, so that's something. But all the other stuff's just waiting, isn't it? But carry on the good work with this sort of thing. Thank you.
Report's as fun as possible, and that one was pitched at the right level. I'm taking it. So thank you very much. Yeah, there's a lot still ongoing.
Anybody else wish to come in? Councillor Wheeldon.
Just a comment. I might be a little bit rusty, but I always thought there had to be some fundamental reason to be able to appeal from a decision. And, you know, I do see this being used as a tool for them to be able to continue to ply their trade. And while things are adjourned and I didn't get the date, and can it be adjourned again, and so on, it's almost worth their while of £2,000 because they can earn an awful lot more than that. Or am I being cynical? I just don't understand what the purpose of an appeal is. I was always, well, I am rusty. It's been some time, but there had to be a fundamental reason that they disagreed and could prove disagreement with the decision in the magistrate's court to go further.
Not rusty at all, no. There has to be a reason, and the reason is, generally speaking, that they believe the council decision is to be unreasonable or wrong. It's then for them to prove that when they get to the court that it was unreasonable or wrong. Certainly in the one case that we actually managed to half finalise, the court were very dismissive of the appeal being made. However, they have that statutory right under the legislation to allow them to do it. You're quite right, and I think I even said it the last time we spoke about it. It is a tool to allow people in most circumstances to carry on plying their trade. What they may or may not realise is obviously we can make applications for costs if we're successful. Irrespective of that, they're going to have to pay their own legal representative once, perhaps twice, if they appeal to both courts. If they have an appeal dismissed at magistrates and go to Crown, then we'll likely be awarded costs in the magistrates. If we're successful at Crown, we'll likely have some more costs. So not only are they paying for 2 lots of their solicitors' fees, they're paying for 2 lots of our fees, and they're paying for their appeal in the first place. So that all relies on them, from our point of view, not being successful at either court, to either level of court. However, it's a statutory provision that's there. It's unfortunately well used. And it is something we're stuck with. In relation to the one who didn't know that was their date, it actually wasn't detrimental to us at all because they're not driving at the moment. It was a refusal to grant a new license, so they're just not employed at the moment. But for several of the other ones who we've revoked or refused to renew, by virtue of submitting their appeal, it allows them to carry on.
Thanks, Matt.
raise of hands, so I'll take members. Do members actually wish to note the contents of this report? Yeah, thought so. Move on to item 11, which is the minutes of the Public Protection Subcommittee meetings. And these minutes can be found on pages 101 to 102 of your pack. Are members content that we could take them as being read? That's fair enough. Item 12 is urgent business. I've not received any items of urgent business. And since there are no public protection closed business matters this evening, I will now conclude the meeting as being over. The meeting of the next meeting is Tuesday, the 21st of March. So have a good evening, a safe journey home, and we'll see you all then. Thank you.